Well, good afternoon, everyone. Thank you so much for joining us for another GWL Business Cafe 3 in 30. My name is Zoya Alam. I am an associate at Goulart Workplace Lawyers, and I have with me my colleague, Rajvi Binder. So today our theme will be a year in review. Rajvi and I are still sort of getting over the fact that we're talking about 2022 when we're still trying to process everything from 2020. So bear with us as we give you a little bit of a year in review for the past year, and we talk about themes to move forward to the next year. So our topics today will include COVID-19 and employment law updates, Bill 27, and updates on terminations. I will go ahead and get started with COVID-19 updates and employment law. So the topics that I'll be covering under this heading will be mandatory vaccinations, new COVID-19 related ROE codes, and the status of the infectious disease emergency leave. Okay, so vaccine policies. So we've done a number of sessions on vaccine policies. So I'm not going to get too far into what has to be, what has to go into a policy, etc. But there are some updates that I wanted to talk about. So Ontario introduced a new regulation, which was later amended, which created a legal requirement for certain businesses and organizations to establish a vaccination policy in accordance with public health. Now, the scope of the policy, as I mentioned, we have some of our previous webinars in our YouTube app where you can review and see any specifics about what would be included in those policies. But essentially, the policies needed to set out precautions and procedures that the business or organization has implemented to protect against COVID-19 and vaccinations in the workplace. The mandatory vaccination policy requirement does not mean that employers are required to make vaccinations mandatory in the workplace. So, for example, some employers have said, show us a proof of vaccination. If you don't disclose vaccination status or you're not vaccinated, then some alternatives may be, for example, working remotely where possible, getting tested in the workplace, etc. So the vaccination policy will provide for other alternatives. Other employers have said, well, our vaccination policy is going to say that vaccinations are mandatory. And so this is sort of where that million-dollar question comes up, where can an employer make vaccinations mandatory, and what can you do to enforce a vaccination policy? So a common question for us has been, can we terminate employees who refuse to get vaccinated? So generally, an employer can terminate an employee without cause as long as it's not discriminatory and not related to a human rights reason, as long as they pay a package. Now, the question becomes, if the employee is not following the employer's policy, can an employer terminate for a cause for non-compliance with the mandatory vaccination policy? And at this point, it's still an undecided issue in the courts. There have been some decisions from the unionized context in arbitration, where some arbitrators have decided upon the issue. So these two decisions I've listed here are United Food and Commercial Workers Union and the Electrical Safety Authority. So in the Electrical Safety Authority case, the arbitrator assessed that the reasonableness of an employer's vaccination policy in that case was actually it was found to be unreasonable. So in that policy, it was also, and just is to remember that this is in the unionized context, and this is an arbitrator making a decision. So the employer's policy was found to be unreasonable in that it required employees to, it said that employers could be disciplined, discharged, or even placed on a leave of absence if they did not get fully vaccinated. And the arbitrator had decided in that case that that was an unreasonable policy. Now, one of the things the arbitrator noted was that the situation involving COVID-19 is an evolving situation, and it really depends on the circumstances of the employer. So in workplace settings where there's high risk, especially involving vulnerable populations, populations, then mandatory vaccinations may be necessary and required. So the arbitrator did note that in the decision. But one of the takeaways from that decision is really the employer really needs to be able to show evidence of the need for mandatory vaccinations and explain why other COVID-19 measures are not sufficient, and why it is within the scope of the employer to impose that vaccination policy. Now, in contrast, there was the United Food and Commercial Workers Union decision, and in that decision, the arbitrator upheld a mandatory vaccination policy and said that it was reasonable. Now, again, remember that this is the unionized context and there is a collective agreement in place. So the collective agreement in that was very specific, and it already had some provisions in that agreement that said that, for example, employees who are assigned to certain client sites would have to be vaccinated. So there were already some provisions in that collective agreement that the arbitrator had considered in upholding that a mandatory vaccination policy was reasonable. But this is the first decision. The United Food and Commercial Workers decision was the first decision that upheld a mandatory vaccination policy as reasonable and enforceable and compliant with the Human Rights Code and the Occupational Health and Safety Act. And sorry, if you have any questions, you can put them into the chat and we will get to them at the end of the chat, at the end of the presentation. Moving forward, Employment and Social Development Canada provided additional information for employers to help employers issue records of employments. So there's a number of different variations. So, and these are related for COVID-19 related issuances. So, if an employee is no longer working because the business has decreased operations or closed due to COVID-19, then the employer should use code A in the record of employment for shortage of work. If an employee is sick or quarantined because of COVID-19, you would use code D, illness or injury. This is the one that's a little bit trickier. It's if the employee doesn't report to work because they refuse to comply with your mandatory COVID-19 vaccination policy, then ESDC has said you can use code E, quit, or N for leave of absence. So it depends on what your policy says, and then it'll be a bit of a battle for the employee to figure out, is it really that they quit, or was this imposed on them? And it'll be up to the employee to allege wherever they need to. But for the employer's purposes, you would use code E or code N in compliance with your policy. And then if you suspend or terminate an employee for not complying with your mandatory COVID-19 vaccination policy, you can use code M for dismissal. And then finally, just an update on the infectious disease emergency leave. The Ontario government has extended the temporary relief measures, and at this point, they're set to expire on January 1st, 2022. We will keep you posted on if there's any changes to that. And I'm going to go ahead and hand it over to Rajvi.
Thank you, Zoya. Good afternoon, everyone. In the spirit of changes that are taking place, the provincial government decided to introduce more changes. So we have the Bill 27 Working for Workers Act. You may know that on October 25th, the provincial government introduced this bill, which is currently being read, and there's a lot of debate going on about it, but if passed, it will create significant new employer obligations and rights for workers in Ontario. So the bill introduces various amendments to various types of legislations, which I will discuss, but under the Employment Standards Act, there's quite a few proposed changes that are taking place. And the first is disconnecting from work idea. So if passed, this bill will require only for employers who have 25 or more employees to develop a disconnecting from work policy that will be implemented within 6 months. of the effective date, and the policy will include reasonable expectations about response time for emails, and encouraging employees to turn off their turn on their out of office email notifications when they're not working. The idea is to be free from performance of work, and the term disconnecting from work is proposed to mean not engaging in work-related communications, including emails, telephone calls, video calls, or sending or reviewing other messages. We don't know at this time who this is going to be applicable to, and what workers, if any, will be exempt. I'm assuming, for employers out there in the manufacturing, distributing industries, this may not be applicable to workers that are working on a shift basis or, doing deliveries. But for workers in a corporate setting, where, it's office work, this may be applicable. We don't have a lot of information right now, only that, if you are an employer with 25 or more employees, just watch out for this requirement because it may be applicable to your employees there. And it will also have an impact maybe on how the businesses will address, work outside of a certain time period. So some things that some employers will have to rethink. The second and quite a significant introduction is the provincial government is banning the non-compete provisions in agreements. So the only exception to this is if your business is undergoing a sale of business or part of a business where the seller becomes an employee of the purchaser. In that context, you would be permitted to enter into a non-compete, but other than that, there's no more non-compete clauses. So there's a lot of uncertainty around this because for current employees who have these provisions in their employment agreements, we do not know what impact this will have and how to address it at this time. Something to be mindful of if you guys are hiring new employees, you may want to rethink adding a non-compete provision in your employment contract, given that down the road, it's not going to be enforceable. This does not preclude an employer's right to include non-solicit and confidentiality provisions, but there's no more non-compete. For businesses, it will impact your hiring because you may need to rethink when you're bringing on upper management and executive level employees who will have access to proprietary information, how you are going to protect the business from your competitors. And this is a huge deal out there right now and is being debated amongst. It'll be interesting to see, what, if any, there'll be any exemptions. But right now, the only exemption we have is the sale of business. But in the spirit of this non-compete agreement that they have introduced, generally speaking, courts have struck down a lot of non-compete agreements. So it is, I think the ministry is just thinking a lot of these agreements have been struck down. So, there is really no point to prevent a worker from earning a living. And I mean, unless there's defined parameters around this, right now, it is a big game changer for a lot of businesses out there who have existing employees and how to deal with new employees from non-competing. Next, under the ESA, we have major changes that are happening to the temporary help agencies and recruiters. So even if you are not in the business of temp agencies, if you use a recruiter or deal with the temp agencies, this will be applicable to you. It is now a requirement for recruiters to be licensed, and for temp agents to have a license to operate and to be in good standing with the ministry. The license is granted by the Director of Employment Standards. You would file an application to get approved for the license, which will need to be it will need to be renewed annually. So each year you will have to renew the license for temp agencies and recruiters out there. How this will impact businesses using them is if you don't do your due diligence in ensuring that the recruiter you're dealing with or the temp agency you're working with is not licensed, the ministry can come knocking on your doors and you could be penalized for working with an illegal agency or recruiter. So it's collateral damage. You want to make sure if you are using a recruiter or temp agency that, you know, if this bill is passed and the proposed date for this to take effect is 2024. So we are a couple of years, you know, there is a couple of year time frame for this to come into effect. But as we know, the years go by really fast. When this do come into effect, you do want to be mindful of your obligations in ensuring that you're dealing with someone that's in good standing with the Director of Employment Standards. If the temp agencies or the recruiter's license is not approved, so it's revoked or suspended, the party does have the right to file an application before the Ontario Labour Relations Board to have them review the decision and to override the Director of Employment Standards decision, or the board may affirm the ministry's decision. We also see changes with the Workplace Safety and Insurance Act. So the bill will repeal existing sections in the act that deal with the insurance and reserve funds. And they've added this new section called the distribution of surplus. So the amendments provide for distribution of surplus insurance funds, and employers will be permitted to have access to these funds. Again, we just have broad strokes on what these amendments are, not a lot of detail, but basically, I think the idea is to incentivize employers who may not have any accidents in the workplace to have access to this surplus fund that's available. And it's also to provide more of a streamlined process in getting surpluses, or access to the funds. Okay. Under the sorry, go ahead.
There's a question in the chat for you regarding the disconnect law. It says, do you think it will exclude managers or professionals, etc.?
I think so. Just like we have exclusions under the Employment Standards Act for overtime pay and other conditions where upper management, it does not apply to upper management. I'm assuming there will be some sort of exemptions in place. Again, we don't have that information right now. They haven't even defined clearly what workers and which industries, which professions it would apply, and which would be and who would be excluded from that requirement. But if once we do receive more information, we will definitely inform everybody about the exclusions. But it's a good presumption to make that management, upper management, anyone in management would be exempt from this requirement. I don't think lawyers, it would apply to lawyers, unfortunately, and I don't think it'll apply to certain like the healthcare workers, as well as accounting, like those type of professions. Again, I'm just basing it off on an assumption. Once we get more information, we will provide the details. All right. Okay, so under the Occupational Health and Safety Act, sorry, Veronica, if you could go to the previous slide. Yeah, this is just a minor amendment being made. Again, this may not be applicable to many of you guys out there, but for those who have packages being delivered or workers that are in the delivery and distribution business, this would be applicable to you. It is now a requirement for business owners to allow delivery workers to use their washrooms if they are delivering or picking up items. Again, I think it's just to provide access to those workers. I guess maybe there are incidents out there where they've been denied access. And there are proposed exemptions to this rule, which are basically if it's unreasonable for practical reasons, you can't have the delivery worker use your bathroom, you can deny them access, you know, health and safety related concerns. If it also would be, if your workplace is the location of the washroom is part of a dwelling, you can deny them entry. And then the other exemption is depending on the type of the work at the workplace, if the conditions of the work, you know, limit user access to the bathroom. Again, with this, you want to be mindful that if you're, you know, human rights related considerations, because now they do have, if this bill is passed, the right to access those washrooms. So if you're denying entry, you want to make sure you fall under one of those exemptions that's being proposed. Okay, moving forward, another amendment that's being made is to, I've never worked with this piece of legislation, but it's for those of you out there that hire foreign trained individuals. The idea behind this is to remove Canadian experience requirements and to remove those barriers so internationally trained individuals can get their license in certain regulated professions to it's just to make the entry more seamless for them. So that's another amendment that's being made. Okay, and then, sorry, I've spoken with WSIB. Oh, my apologies if I've not been speaking in alignment with the PowerPoint slides. Okay, another amendment that's being made is with the under the Ministry of Agriculture, Food and Rural Affairs Act. I'm not sure if this is going to be applicable to many of you, but basically the bill proposes to authorize the minister to collect information, including personal health information for the purposes set out in that legislation. Again, we don't really work directly with that legislation, but it's just to allow the minister to be able to request information. And okay, and then there's another amendment being proposed under the Employment Protection for Foreign Nationals Act, and this deals with again, it deals with recruiters. They'll be liable to repay fees, and it allows the officer, the employment standards officer, discretion to make orders with respect to collecting and repayment of fees. Again, a lot of these amendments that are being made to various types of legislations, we've got broad strokes on content, nothing very specific or in detail. So when the bill is passed, we will have a greater insight into what exclusions, what limitations, if any, are applicable regarding those proposed changes. And I'm just going to pass. Please, if you do have questions, I'm happy to take questions regarding those changes. I don't have a lot of information, just the information that I've shared with you, but I'm happy to take any questions regarding the proposed amendments. And I'll pass it to you, Zoya.
Thanks, Rajvi. Again, if people have questions, you can put them into the chat and we will we'll do our best to respond. Okay, so my next section is about contracts and updates to termination provisions. Many of you will remember the impact of a case called Waxdale, which required many employers to update their termination provisions because of this Court of Appeal decision that said many of these just cause provisions, that the just cause section of the termination provision has to be enforceable as well. So many employers ended up having to update those contracts. There is a new case that maybe provides a little bit of hope for those older provisions. It's called Rahman versus Canyon Design Architecture. And essentially, in this, you had an employee, her name is Farah Rahman, and she was employed by Canon Design. Before her employment began, she negotiated her contract, and she had the assistance of a lawyer. So the lawyer negotiated the terms of her contract. The termination provision was also negotiated, and so the court actually upheld the just cause section of the termination provision and said that because the parties were both sophisticated, you had two reasonably sophisticated parties with equal bargaining power who entered into the contract, there was no need to be so strict with the termination provision in the just cause section. So the context in which the employment agreement is entered into will be considered. It's one of the things that the case has demonstrated. So they'll look at things like equality of bargaining power between the parties, and then the court had also held that there was an intention by both parties to comply with the ESA. So the termination provision should not be struck down. And so there was one more part of the case that was interesting, because in the previous Waxdale case, there was issues around and questions around whether a saving clause is effective to save the rest of the termination provision, and it seemed like it wasn't. But in this case, the court actually said that because of that saving clause, that there was a demonstrated intention to comply with the ESA, and so it could be that saving clauses may be effective. And then there's this question about dismissals during the pandemic and whether they can lead to longer reasonable notice periods when an employee is terminated, and whether they're entitled to common law notice. And so there are some decisions that state that came out in 2021 that stand for the premise that terminations that occurred before COVID-19 should not be treated the same as those that occurred after COVID-19 began. So there was a case called Yee versus Hudson's Bay Company, and in that the employment contract was terminated in August of 2019. So the pandemic, though it resulted in some difficulty in the employee finding work, the court ruled that the termination should be looked at differently pre-pandemic, pre-COVID-19, and then and post-COVID-19. Whereas there was another case called Kraft versus Firepower Financial Corp, where the employee was terminated in March of 2020, and so the employee's job search was right in the middle of the pandemic, and so the court treated that termination differently. Rahman, there's a question in the chat that says, would your agreement requesting the candidate to have a lawyer review it meet the equality of bargaining provision? I understand the question. So the question is, if you have a provision in there that says that the candidate should get the contract reviewed by a lawyer, would that meet the equality of bargaining provision? So yes, I mean, if the employee does end up having a lawyer review the contract, then according to this case, then that is something that the court would consider to decide that there was equal bargaining power. Yes, and resignations. So, I mean, I don't think that this is particularly new, but resignations must be clear and unequivocal. So there are some cases where, if there's any questions about whether an employee has actually resigned or not, then it's better for the employer to confirm the intentions and ensure that there is a clear and unequivocal resignations. There's some previous case law about if an employee in the moment and spur of the moment resigns, there might be a requirement for a cooling off period. And once the employee settles down and to figure out whether there was really a resignation there or not. And then there's this case about Anderson versus Total Instant Lawns. So in this case, really the court, and I'm mindful of the time here because we said 30 minutes. In this, the court really said that employees who refuse to work unless new employment conditions are met, or if they refuse to perform their job responsibilities, it could indicate that the employee has repudiated the contract, so there may be a resignation there. And that's all from us. If people have further questions, please feel free to put it into the chat box. But in any case, I think we've answered the ones that have gotten so far. So we'll give it a few more minutes. Thank you so much for joining us today for our year-end review. As always, Rajvi and I are available. If you have any questions, you can definitely send us an email. We'll put our emails into the chat box as well. And then you can also follow us on LinkedIn and on YouTube. You can view any of our webinars. Thanks so much, everyone.